guidance on what we're going to do. So we've been doing the legal methods sessions, and last week we did learning outcome 3. My name's Shazia Khan, and today is learning outcome 4, but I'm just going to give you a summary of what we did last week in learning outcome 3, so you've got a little bit of an idea. And Alu, as you've missed the 1, 2 and 3, you need to go onto Moodle to get some resources and the slides, okay? So you need to go onto Moodle to get some extra additional reading and your PowerPoint slides for the last ones you've missed.
Okay,
so in learning
outcomes, where are they on Moodle?
They're on Moodle on the legal methods module, which we're doing now.
Okay.
So you should have access to that. If you don't have access to that, you need to contact Victor, okay?
I have my Moodle.
Yeah, so you should have the legal methods module. It's a unit, and then you need to check your Moodle on Moodle, your slides as well, okay?
Okay.
Okay, so last week we did learning outcome 3, and a little bit of a recap on what we did. We looked at the structure of the criminal and civil courts. We also looked at the different types of courts and criminal justice within the UK, and what kind of judges we have, where they sit. So for example, High Court judges. We also looked at the Court of Appeal. We looked at the criminal division of the Court of Appeal, and how the Lord Chief Justice is president of the Court of Appeal. We looked at the High Court judge, which is the criminal jurisdiction. We also looked at the circuit judges who deal with criminal cases, and then the civil court structure, because there's a difference between civil and criminal court, and they differ in the fact that one is to do with the person sentencing the person, whereas the other one is to do with compensation, and the different types of courts: Magistrates Court, County Court, High Court, Court of Appeal, and the highest court is the Supreme Court in the UK. We looked at each of the courts and we identified what is heard at the courts, the personnel that work within the courts, and also who's bound by the court, and the different types of appeals that are available under each court. So we looked at the High Court, the Crown Court, Magistrates Court. We also looked at the Chancery Division, which hears things like business law, trusts, probate and land law, things like, you know, company directors, things like Companies Act, and when you register a company as well. We also looked at the family division. What kind of things can be dealt with in the family division?
Things related to,
sorry?
Things related to family and children, adoption.
Yeah, children, family, yeah, any sort of divorce proceedings, you know, maybe any sort of resources in regards to what the children, which parent the children should live with. We also looked at the civil division of the Court of Appeal. We looked at the different judiciary, and we looked at how the appointment system works. So do we have a fair system in a judge or judiciary? And we looked at the jury. Excuse me. Why do you think the jury is so important in a case, in a criminal trial? What do you think a jury is? There's 12 people and they're there to decide with the help of the judge whether the person is guilty or not, okay? And they listen to the evidence during a trial. They decide on the facts of the evidence and they draw inferences from the facts to form a decision. And in this case, the judge supports them in this. So they are there to identify whether the person is guilty or not. We also looked at different drawbacks of alternative dispute resolution, things like mediation or ADR. We looked at the European Court of Human Rights, what they dealt with, the European Court of Justice, the Privy Council, and we also looked at the tribunals. So different types of tribunals in regards to things like, you know, you could get tribunals for employment. issues, you know, so if there's any sort of issues regarding employment issues, discrimination, constructive dismissal, they would deal with that. Now, today, we're going to be looking at learning outcome 4, another important bit in regards to the powers. So learning outcome 4 is to understand the civil and criminal justice system and the alternative methods of dispute resolution. So 4.1, we assess the duty to the powers of the police. Now, these powers of the police come within a thing called PACE, P-A-C-E, and that is the Police and Criminal Evidence Act 1984. And they identify a code of practice that police officers must follow. Okay, so they must have the power, but they must follow this. Why do you think it's important that police officers follow this code of conduct? The PACE code.
So they won't abuse their rights.
Yes, excellent. Do you think that happens though?
I think it does.
No, I agree with you. I agree with you. In certain cases, dependent on, you know, maybe things like, you know, a young boy and how he dresses, you know, there's been instances where people have been abused by the police on the, you know, fact that they, you know, the color of their skin. It doesn't matter. You know, there is institutional racism within the police force as well. So the duty and powers of the police are to arrest you. The police need to be reasonable, have reasonable grounds to suspect you're involved in a crime for which you arrest is necessary. So they can't just arrest you, they must suspect something. They must have a reasonable grounds. The police have the powers to arrest you anywhere at any time, including on the street, at your home or at work. The police arrest procedure. If you're arrested, the police must identify themselves as the police officer. So they must give their name and their rank, tell you you've been arrested, tell you what crime that you've been arrested for, explain what is necessary to arrest you, explain to you that you are not free to leave. If you are under 18, the police should only arrest you at school if it's unavoidable, and they must inform your head teacher. The police also must contact your parents, guardian or carer as soon as possible after your arrival at the police station. And this is where the police need to follow that PACE code under that act. Police powers to stop and search, and this is to the PACE code. The police can stop and search you and question you at any time. They can search you depending on the situation. A police community officer must be in uniform when they stop and question you. A police officer doesn't always have to be in uniform, but then if they're not wearing uniform, they must show your warrant card. Stop and search questions. So these are the questions that they will ask you. A police officer might stop you and ask you, what is your name? What you're doing in that area? Where you're going? You don't have to stop or answer any questions. If you don't, and there's no other reason to suspect you, then this alone can't be used as a reason for search or arrest you. Stop and search, police powers. A police officer has powers to stop and search you if you have reasonable grounds to suspect that you're carrying illegal drugs, a weapon, stolen property, something which could be used to commit a crime, such as a crowbar. You can only be stopped and searched without reasonable grounds if it has been approved by a senior police officer. This can happen if it is suspected that you are going to cause any sort of serious violence could take place, that you're carrying a weapon or have used one, or you're in a specific location or area, or maybe there's burglaries in that area that, you know, they need to speak to you about, or just identify whether you're not involved or anything. How you get free legal advice. You must be told about your rights to free legal advice after you're arrested and before you're questioned at a police station. You can ask for the police duties solicitor. They're available 24 hours a day and independent of the police. You should tell the police that you would like legal advice. The police will contact the Defence Solicitor Call Centre, DSCC, and ask the police to contact a solicitor. And you can identify to the police that you want your own solicitor. You know, it's important, if you have your own family solicitor, then you can identify to the police that I want to be called I want to call my own solicitor. And you may be offered legal advice over the phone instead of a duty solicitor if you're suspected of having committed a less serious crime, being disorderly. The advice is free and independent. Okay, so here they must follow police must follow the PACE codes, and these are rules that the police have to follow when they stop and search, arrest and detain, interview and investigate suspects. PACE codes were created by the Police and Criminal Evidence Act 1984 and are available to police officers. And the reason, like you said, that they must follow these codes is so that they don't abuse their powers, because some police officers, the older police officers, tend not to follow these codes, but these codes are there so that it's like a framework of rules that police must follow, you know, a code of conduct. And, you know, especially when they're arresting people and the laws are in place that, you know, there's certain codes. So we have code A, code G, you have different codes that the police must follow, and they must identify the different codes. So the PACE codes cover stop and search, arrest, detention, investigation, identification, and interviewing detainees. And you've got different codes. Code A is to exercise by police officers statutory powers to search a person or a vehicle without first making an arrest, and the need for police officer to make a record of the stop or encounter. Code B looks at police powers to search premises and to seize and retain property found on premises. Then you've got different codes. Code E could be audio recording of interview with suspects in the police station. So these are the codes they must follow before they arrest someone, and there's a procedure on that. 4.2, the role of the Crown Prosecution Service, CPS. So the Crown Prosecution Service, which is referred to as CPS, prosecutes criminal cases they have been investigated by the police and other investigative organisation in England and Wales. The CPS is independent and they make their own decisions independently of the government, the police and the government. The Crown Prosecution Service was recommended by in the Royal Commission on Criminal Procedures report published in 1981 and was created by virtue of Section 1 of the Prosecution of Offences Act 1985. The role of the CPS is to objectively assess police investigations and to prosecute cases satisfying the code for the Crown prosecutors. First published in 1986, second edition in 1992, and third edition in 1994 for lay members of the public, revised in 2000. Prosecution procedure involves a set of papers being received from the police and allocated to the caseworker in the principal prosecution team 2. Now here, who do you think the prosecution works with? Do you think they work with the client, or do you think they work for the Queen, the police?
I didn't get the question, sorry. Can
so
you...
who do you think the Crown Prosecution Service work for?
For the government, right?
They don't work for the government. They're independent of the police and the government. They work for the country, so the Queen. Okay. So like if you're taking an allegation against the police, they must investigate it. For example, if I rob a bank, okay, just an example, I don't rob banks.
No.
If I rob a bank, now, if I get arrested by the police, they follow the PACE code and everything like that, then I'm arrested by the police. So then the Crown Prosecution gets involved because they're the prosecutors. So they will be prosecuting me. So they will have to find evidence that I have committed this robbery.
Okay.
Whereas my solicitor would be saying, no, she hasn't committed this robbery. So the CPS literally work with the police in a way.
Okay.
Okay, so the CPS prosecutes criminal cases in regards to any sort of investigative organizations within the UK, and they're quite a big organization that works with, you know, the solicitors and barristers in regards to working with the CPS, and they actually in regards to that, the prosecutors, I mean, we've gone through all them little bits there where they should be prosecuted. Our duty is to make sure that the right person is prosecuted for the right offence and to bring offenders to justice wherever possible. The CPS decides which cases should be prosecuted. They determine the appropriate charges in more serious or complex cases and advise the police during the early stages of investigation. They also prepare cases and present them at court, because barristers and solicitors work within the CPS. Okay, so then people work for the CPS and they are barristers and solicitors, so they prepare the cases to present at court. It provides information assistance and support to victims and prosecution witnesses. Prosecutors must be fair, objective and independent. When deciding to prosecute a criminal case, the lawyers must follow the code for Crown prosecutors. This means that to charge someone with a criminal offence, prosecutors must be satisfied that there is sufficient evidence to provide a realistic prospect of conviction and that the prosecuting is in the public interest. The CPS works closely with the police, the courts and the judiciary and other partners to deliver justice. So you've got the director of the public prosecutions, you've got, which works down to the senior Crown Counsel, you've got the executive officer, then you've got the Crown Counsel 1, senior clerk, Crown Counsel 2, Crown Counsel 3, and then you've got the senior clerk, which has a junior clerks and works within junior clerk, the petty officer. So this is the CPS organograms of staff and roles and salaries. So the CPS people that works there in regards to what they do. Just a minute. Then the caseworker makes an overall assessment by considering the 2 tests stated in the Code for Crown Prosecutors, CCP, the evidential test and the sufficient test, to provide a realistic prospect of the defendant's conviction on the charge, and an objective test of whether the jury or the magistrates is more likely than not to convict the defendant, and reliability and admissibility of evidence. So they must make sure that the evidence they produce is admissible. So there's enough evidence to identify that the person is going to get prosecuted. The CPS should be independent prosecution body in the criminal justice system with its own offices, with its own staff, and taking decisions of appropriate charges in criminal cases, as well as prosecuting criminal cases. They are there obviously to responsible for prosecuting criminal cases investigated by the police and other investigative authorities in the UK. And they have to follow the protocol of, identifying these 2 tests to see if there's the case that they are going to use is the case that they're going to go to court with is admissible, and there's enough evidence there for them to identify that they should take the case to court. Okay, the CPS have 5 main roles and how it works. So firstly, the CPS look at the evidence of and advise the police on the charge that the defendants should be prosecuted for. They then review the case. They will look at the evidence and all the statements and make sure they understand what the case contains. The hate crime scrutiny group does this. After they decide whether to prosecute or not, they will need to take into account whether it is in the public's interest to prosecute or whether putting the case to court would be a waste of time and money. If decided that the case is liable to go to the courts, then they will prepare it for trial. They will gather all the information that they have on the case and take it to the court for jury to evaluate. Finally, they will present the case in court, and this involves members of the CPS turning up to court and presenting all the evidence and statement that the police have given them to the judge and the jury to make a decision. Now, when I'll give you an example. Do you think when someone is being when a case is going to be taken to the courts, do the CPS need to research and get evidence together for the case rather than just going in?
Yes, of course, it's important that there are.
Why do you think it's so important?
Because if not, they might end up prosecuting like the wrong person, right?
Yeah. And do you think that's happened previously where people have been prosecuted wrongfully?
Yeah, I think it does.
Yeah. Yeah, so, they have to be sure that, they have enough evidence, they review the case, they decide whether or not there's a prosecution, and then they obviously prepare the case and then present it to the court, because there's no point presenting a case to a court and you don't have evidential evidence and you don't have any sort of admissible evidence to identify and submit to the court.
Mm.
They need to, the main issue is they need to review the evidence gathered by the police and provide guidance, and they need to be, once the evidence is gathered, then they can decide on the basis of the evidence whether the case should be either dropped or that the CPS, there's enough merits for the case to go to the Crown Court and then for them to get prosecuted.
Okay.
So for this, they work very closely with the police to get any sort of information. If it's for more severe cases, they will work quite closely with the police in identifying whether there's any merits to the case. They have to, the code for crime prosecution is issued by the DPP under Section 10 of the Prosecution Offences Act. It gives guidance on general principles to be applied when Crown prosecutors make decisions about prosecutions. In cases where the police determine the charge, which as previously indicated are usually more minor and routine cases, the police should also apply the provisions of the codes. So they have to follow certain codes as well, the CPS. They can't just identify that, this person needs to be, sentenced. They have to, identify if there's a prosecution there or not. So then we've got 4.3. Examine the latest reforms to the civil justice process. So Lord Woolf was appointed by the Lord Chancellor to carry out an extensive review of the civil justice system in the UK, England and Wales. He identified several problems regarding the old system and felt that it was in crisis. Lord Woolf found that the civil justice system remained crippled by high cost, excessive delays and complexity of trials. These problems have influenced major reforms which were intended to make enhancements in addition to create a more effective and efficient civil justice system. Firstly was the introduction of the case management, was perhaps the most significant report. And these were the things that were identified. So they identified in the Wolf's report as being too expensive. One of the arguments used against the former civil justice system was that it was too expensive. It could be argued that the system was in favour of wealthier litigants, as many people were put off commencing claims as they were combined with considerably high litigation costs charged by lawyers. So, they were, at the end of the court hearing, they would have such high costs, so, no one would put in a case for any sort of, no one would say, I want to take my case to court or put in a claim. The new rules were enabled so there could be a fixed cost for cases on both fast-track and multi-track cases. Due to the complexity of the civil procedure, lawyers with legal expertise are required to, or in order to draft proceeding and give advice on evidence. The duration of civil procedures also has an effect on the costs. To reduce the complexity of civil procedures, Lord Wolf ensured that civil procedures would be simplified by high courts by producing a single set of rules. So they changed it and then reformed it so it's less expensive for people, so more claims could come through.
Okay.
It was too slow and there were too many delays. Another problem with the civil process was that it was too slow and delays often occurred. Larger claims increase the time length and take longer to be brought to trial. The most delays were found in personal injury claims and medical cases as a result of the lengthy process has had an impact on the financial burden on the victims. In order to speed up the process and avoid delay, Lord Wolf introduced case management in hope to attain this. New landscape of civil litigation. So Lord Wolf is convinced that in the future, litigation will be a less adversarial culture and more cooperative. Since the new civil procedure rules, CPR, came into force in 1999, the position of civil courts has improved due to the considerable changes made by Wolf. But in spite of these problems still remain. The purpose of the CPR, which is the civil procedure rules, was intended to eliminate unnecessary costs, delay and complexity, and to underpin the civil justice system by making it more efficient. The main aim of this rule is the overriding objective. The civil procedure rule sets out the overriding objective of the whole system. That rule should enable the courts to deal with cases justly. Dealing with the case justly includes ensuring that parties are all at equal footing. So everyone is treated equally. 4M1, compare and contrast the benefits and drawbacks of the different types of alternative dispute resolution. In Lord Wolf's Access to Justice report, the use for alternative dispute resolution, which was referred to as ADR, was greatly encouraged. It enabled parties to explore ADR, introducing a single set of rules governing proceedings in the High Court. In the High Court and the County Court, enabling a shortened time period, timetable for cases to reach a court and the length of trials and more case management by judges. Following the CPR, the courts adopt a strict interpretation of whether people should be obliged to use ADR. ADR is alternative dispute resolution, or external dispute resolution, which is the term means any procedure agreed to by parties or dispute which they use the services of a neutral party to assist them in reaching any sort of agreement and avoiding litigation. So ADR is used as mediation before it goes to court. So sometimes people mediate and it's resolved, isn't it? When you go through mediation. I'll give, when you go through mediation, it is sometimes resolved, isn't it? Yeah. And it's cheap. It's a cheaper option. So if you're mediating, okay, so you've got a third party coming and helping you. You're mediating something. It's settled. Then they don't have to go to court. Then. So that's what the CPR rules wanted to adopt, but also Lord Wolf wanted to look at more ADR resolutions because they were quicker and cheaper than ordinary courts. So there are 3 different types of alternative dispute resolution, cheaper and quicker than ordinary civil. One form of ADR is mediation, which consists of a third party, mediator, just 1 minute, mediation, who acts as a go-between the parties to reach a mutual acceptable settlement. Mediation is a voluntary process. If parties should fail, the parties will have preserved their position. So for example, mediation would be if a business, yes, is in dispute with another business, okay? Before they go to court, take each other to court, they must have a mediation. Okay, and the mediation is that they would try to mediate between each other and come to some arrangement. Do you understand?
Yeah.
Rather than going to court, they'd come to some arrangement and they'd identify that this arrangement is good for them and they will not go to court. So it's cheap and quick way of doing it. The second one is, another form is arbitration. Arbitration is much like mediation, and it's governed by the Arbitration Act 1996 and involves an arbitrator who also assists the parties to resolve their disputes. Arbitration can occur in more than one way. Firstly, by commercial disputes, where contracts involving stating that disputes will be subject to an arbitrator. And secondly, parties intentionally agree to go to the arbitrator to solve their disputes. Arbitration is much like mediation and or negotiation, and it is there to arbitrate and to help individuals come to an agreement. And then conciliation is another method that's involved. Involves a third party who's called the conciliator and who is independent of the parties, so he has nothing to do with the parties. The conciliator advises parties to resolve their disputes, and negotiation is the cheapest and quickest form of ADR. It involves a third party, the negotiator, who tries to resolve the dispute by negotiating. Lawyers continue to negotiate on behalf of their clients, even if the court proceedings have not commenced. In addition, ADR is a useful method of solving disputes between parties without having to resort to court. Do you think this is quite a popular thing that is being used now?
No, I don't think. Maybe in the business sector.
Oh, no. Do you not, who think, sorry, someone said they don't think it's a good thing to use?
No, I heard like you think it's a good thing to use.
Yeah, it's quite there are advantages of it, because you know their ADR processes are less, you know, are flexible, cost efficient and time effective, and give the parties more control over the process and the results. So you know they have more control over it. Instead of going to court, you know, they would get this dealt with a mediation.
Okay, but is the resolution guaranteed? Like,
Yeah, because I mean, if you don't resolve it, then it goes to court. But if it's resolved within both parties and a mediator or a conciliator there, then it's more efficient, more flexible, more time consuming. So it's one of the mediations is kind of a good thing to have.
okay.
Because it's less formal, you know, it's not more formal like a court.
Okay.
There can be also, you know, some of the advantages are that it's, you know, flexible and it's cost efficient, but there's also some disadvantages as well. It can also lead to naive or ill-informed parties to make decisions against their interests. So, you know, sometimes people don't understand certain things. They may need to go to court. So, you know, if someone doesn't understand anything, it's less formal and less expensive, but it can also be if someone is ill-informed, you know, given the wrong advice, they may need to go to court after.
Okay.
But it's used a lot in, you know, like divorce cases as well, trying to come to mediation with the husband and wife, try to mediate, you know, and try to come up with resolution for the kids and also for the house and things like that. It's quite a big thing used in divorce cases.
Oh, wow. Okay.
Yeah, it's because they try to, because there's children involved in a marriage, they don't want the children to be involved in courts. So they try to mediate before they go to court.
Okay.
Because sometimes the husband can say, you can have the house and, you know, I'll have the car or something, you know, so they mediate and come to a resolution there.
Okay.
4D1, analyze social, political and economic causes of miscarriages of justice. A miscarriage of justice has been defined as a grossly unfair outcome in a judicial proceeding, as when a defendant is convicted despite lack of evidence of an essential element of crime. Ghana 2000. What causes miscarriages of justice? Causes of miscarriages of justice include plea bargains that offer incentives for the innocent to plead guilty, sometimes called an innocent prisoner's dilemma, confirmation bias on the part of investigators, withholding or destruction of evidence by police or prosecution. There are various cases of miscarriages of justice that occurred, causing lack of confidence in the criminal justice system. Do you know what miscarriages of justice are?
No, it says kind of an
Sorry?
injustice. It's kind of an injustice.
Injustice, yes, it's injustice. There's been, there's been cases where people have, been wrongfully convicted, and there's been lots of miscarriages of justice in the UK, where, there's been people convicted for the wrong reasons, and detained for the wrong reasons. And there are so many miscarriages of justice from the police. That they've identified that, oh, we've just seen this young boy of black ethnic culture, and we should arrest him because he's been beaten up by a group of young white male young boys. So they protect the young white boys. And this was the case in I don't know if you know of the case of Stephen Lawrence.
No, I don't.
Stephen Lawrence was a young black boy, and his mother is still fighting today in regards to miscarriage of justice and institutional racism by the police force. And till this day, and it's 25, it happened in 1993.
Oh.
What happened was, he, at the age of 18, he was murdered for an unprovoked racist attack. He didn't know his killers, and he didn't know, they didn't know him. But it was so important that a lot of the evidence went missing, and there was loads of miscarriages of justice in this case. And it's something that's so interesting. You should watch this, because his mother, I think she is Jamaican, and she is still 25 years on. She is still fighting the case for miscarriages of justice. Because there were so miscarriages of justice in his case, where they lost a lot of the evidence. They still, the family, it took them, it would take 18 years after the murder, Stephen, and the scraping of the centuries. It looked at the issue of his actual murder sparked a lot of interest in the Metropolitan Police in London. And, there were loads of families. His mother set up a foundation, and it looks at the miscarriages of justice. So interesting. There's a documentary made on it as well, so have a look at it. It's called Stephen Lawrence case. And have a look at it. It's so interesting. If we've got time in the next week or so, I'll have a look, if I can have a look for you. Okay. What are the most common causes of wrongful conviction? Again, the Innocent Project lists 6 contributing causes for wrongful convictions: eyewitness misidentification, false confessions or admissions, government misconduct, inadequate defense, so and then informants of the police, so snitches, jailhouse snitches, unvalidated or improper forensic science. These are some of the references that have been used in today's session, and law teachers, quite interesting there as well, that you could have a look at. And also the civil justice system in the UK will help you in regards to anything to do with the civil side of it. But also another really, really interesting website that you could go on in regards to this is the police powers of arrest and your rights. Also the cps.gov.uk is another website which is quite interesting for you to use. And also please go on to Moodle in regards to any sources, additional sources that you need to use. And I'll show you the link to the documentary after this session as well. But has anyone got any questions before we finish off the session?
No.
No? Anyone?
No.
Jacqueline?
No.
Olu? No?
No, I don't have any questions.
Sorry? Yeah?
No, I don't have any questions.
Oh, you don't have any questions? Okay. So next week I think we've got learning outcome 5, and let me just have a look. Learning outcome 5, and then the week after we've got the assignment discussion. So what I'm going to do, I'm going to stop sharing this, and then I'm going to stop recording, and I just want to show you the documentary on Stephen Lawrence if you want to watch it in your own time, okay?
Okay.
On miscarriages of justice. I'll just stop this. Yes.